morning. As you are rightly aware, President Muhammadu Buhari-led administration has recorded outstanding successes and indeed achieved remarkable feats in the key areas of justice reforms, the fight against corruption, and good governance that are rooted in judicial reforms, which in effect translated to improvement in justice dispensation and efficiency of the Nigerian jurisprudence. In the course of implementation of these major reforms, the federal government has made major strides in ensuring the diligent prosecution of cases, which in effect translated into major convictions, has equally translated into major general reforms in governance through legislative, executive, and associated incidental justice sector reforms and process. The objective of this gathering and this engagement this morning has already been laid, and it is to the effect that the public, members of the press, and Nigerians are updated on the general position of things as it relates to the justice sector. It is on this basis that you have gathered here today the Federal Ministry of Justice, a delegation from the Federal Ministry of Justice, chaired or headed by the Attorney General, the General Justice Sector departments and agencies of government under the direct supervision of the Attorney General of the Federation and Federal Ministry of Justice, that are here to engage you and provide an insight associated thereto. In the course of my presentation, I will start by way of giving you an insight as to what successes, if any, has been recorded by the Federal Ministry of Justice in its own right. And then I progress and proceed to the successes, if any, that were recorded by the departments and agencies, parastatals, under direct supervision of the Office of the Attorney General, and progress further by way of addressing successes, if any, recorded by other agencies of government over which the Office of the Attorney General of the Federation exercise oversight by extension, by law and by the Constitution. Not only the ministries, department, and agencies under direct supervision of the Office of the Attorney General are indeed involved in the justice sector administration, but by Constitution and the enabling laws, the Office of the Attorney General exercise extended supervisory role over some agencies of government. For example, when it comes to prosecution, the Office of the Attorney General has the responsibility of general oversight on all prosecutorial agencies in the country, and that role is constitutional. So now, coming to my presentation, which is indeed committed to writing, I may not necessarily be wholeheartedly governed in my presentation by the documented presentation, but then I will try as much as possible to operate within the circumference of the presentation documented as presented. Let me begin by welcoming you all to this 46th session of the weekly State House briefing, which I have the privilege to anchor. My briefing will focus on strides made under the administration of President Muhammadu Buhari justice sector administration, and policy reforms. You may be aware that the agenda of this administration is firmly anchored on respect for the rule of law, so our efforts have been to improve the capacity of justice sector institutions, strengthen anti-corruption agencies, enhance access to justice, improve prosecutions, and asset recoveries, among others. Distinguished ladies and gentlemen, the justice sector encompasses all institutions of government involved in administration, enforcement, and dispensation of justice. This sector extends beyond the federal level and cut across sub-national entities and the three arms of government: the judiciary, the executive, and the legislature. Effective collaboration and coordination is therefore at the crux of the mandate of Federal Ministry of Justice. Consequently, this briefing highlights not only the policy initiatives of the Federal Ministry of Justice, but also extends to critical achievements in the justice sector through policies and initiatives targeted at improving legislative policies, the judicial system, correctional system, law enforcement, constitutional guarantees, and other critical components of entire justice sector system. All these are fundamental to ensuring access to justice, safety, security, and in combating corruption as well as economic and financial crimes in Nigeria. As we may all be aware, the justice sector, as with every other sector, has continued to witness some challenges, in consideration of which we made efforts to identify recurring challenges and impediments to the administration of justice. Through the instrumentality of the Office of the Attorney General, all justice sector stakeholders have built consensus, which identified these challenges and resulted in development and adopted of the first ever national justice policy in 2017. Following this landmark achievement of consensus building among the justice sector stakeholders, all justice sector institutions across the country have continued to collaborate and provide frameworks for the realization of the objectives set out in the National Justice Policy. It is our firm expectation that the full implementation of the proposals in the national policy on justice sector would lead to greater synergy and shared knowledge amongst all stakeholders involved in the administration of justice. But what successes we are about to unfold has been the achievements under EFCC, NDLEA, ICPC are equally involved in direct prosecution. So I may perhaps, maybe when I get to the presentation on the parastatals, give you further insight as to what they have done in their own case as it relates to criminal prosecution. So Federal Ministry of Justice, within the 18-month period I'm talking about, was actively involved in prosecution of 312 criminal cases for various offenses, including terrorism, maritime offenses, armed robbery, cybercrime, kidnapping, among others. We have so far, as a ministry, secured over 1,000 convictions on terrorism within the period in consideration. 1,000 convictions on terrorism. Again, convictions were secured in 45 cases by complex case group. The complex case group, for your information, is a unit established in the Federal Ministry of Justice that requires specialization in prosecution of certain special cases that borders on maritime and indeed associated special cases. And the Federal Ministry of Justice has, through the complex casework group, succeeded in securing 45 convictions that relates to maritime and special task force on electricity offenses, and that convictions were secured across 13 zones of the ministry. Participation in the Joint Investigation Committee, as you rightly know, for the success of conviction, criminal conviction for that matter, there is indeed need for extensive investigation. Not only an investigation, but indeed having an investigation report that must naturally stand the test of proof in court, which by processing must be translated and processed into an actionable evidence. So arising from the consensus building arrangement, it is no longer business as usual, where the case in contention requires multi-stakeholders, connectivity, collaboration. The Federal Ministry of Justice has created an avenue for collective participation as it relates to investigation. For example, if you are talking of terrorism, it is only natural that other agencies of government that are involved in an investigative process associated with terrorism cases must be involved. So, for example, the DSS may necessarily be involved, inclusive of the military in certain cases, when perhaps field operations were the product of the cases that came around us. And when you are talking of economic crime cases, for example, it is only logical that the EFCC must be involved. And governance cases, for example, the ICPC must naturally be involved. So what I'm saying, the consensus building arrangement is paying enough. Paying enough in the circumstances that the agencies of government are now working together as it relates to whatever issue is at stake. The Federal Ministry of Justice is equally engaged with the International Criminal Court and ongoing satisfactory prosecution of 7 potential ICC cases to obviate the trigger for any ICC prosecution. At the international level, for example, there are rules for engagement taking into consideration that we are engaging in the northeast, for example, the Boko Haram, in the southeast, the IPOB, and in the northwest and central, for example, the bandits and associated things. All these things, by the rule of international engagement in respect of which Nigeria is a member, there are certain code of conduct that is expected to be complied with. And when you are operating in breach of those code of conduct, the actions or inactions may eventually translate to a considerable case before International Criminal Court. So we are equally working together as a system to ensure at the end of the day that nothing adverse comes our way as a nation in terms of breaches associated with the International Code of Conduct of Engagement, both military and otherwise. Again, out of desire to deploy technology into what we are doing, as far as governance is concerned, as far as the fight against corruption is concerned, we have deployed a state-of-the-art case management system known as Intela, and this is a smart case management system that not only warehouses all terrorism-related cases from 2017 till date, but also intelligently provides needed statistics. For your information, Nigeria is not operating alone in the fight against terrorism, anti-corruption programs, and associated things. And it is only logical that information and intelligence reports are being shared. The idea of remaining analog and manual in operations, we felt, is not good enough for the system as it relates to international engagement. So we have now succeeded in putting in place a technologically based case management update arrangement, which will now enable us to respond rapidly and speedily to international inquiries arising from our international engagement responsibilities of mutual legal assistance, among others. So, on cases relating to terrorism, I'm talking of the local cases with particular reference to Kainji trial. As you rightly know, the terrorism cases are being prosecuted in Kainji. The ministry, through the complex working CCG unit, is coordinating the next phase of terrorism-related trials in collaboration with the Federal High Court, the Legal Aid Council, and the Defense Headquarters. The ministry has concluded remodeling action towards structure at the Wawa Cantonment, Kainji, to accommodate 8 courtrooms, judges' chambers, living accommodation, lawyers' dressing room, and conveniences to make them conducive for judges, witnesses, as well as defendants. So we are not only confronting terrorism head-on, but we are taking steps to make all necessary provisions as it relates to facilities and indeed a kind of having in place a sustainable arrangement for the prosecution of terrorism cases. What obtained before the coming in place of this administration was an ad hoc arrangement whereby periodically arrangements are made for prosecution of these cases. But then we are now taking steps to ensure at the end of the day that a sustainable arrangement, both in terms of facilities, structures, and indeed as it relates to capacity building, are put in place for addressing, checkmating, and confronting terrorism cases head-on. So the activities of the Ministry of Justice equally are extended to sexual and gender-based violence. In response to the growing incidences of sexual and gender-based violence in the country, the President directed the establishment of Inter-Ministerial Management Committee on the eradication of sexual and gender-based violent offenses. Further to this, the ministry established a unit. The activities of the ministry in this regard has yielded the following successes. 1, establishment of special protection team to provide access to justice for victims of SGBV. This includes prosecution of these offenses. The ministry is currently prosecuting over 30 cases ranging from rape, unlawful sexual intercourse, and defilement of children, and homicide as a result of SGBV policy of the federal government. Again, we created a solution room to promote access to justice for child survivors of sexual violence in the FCT. Again, we are coordinating all MDS investigating and prosecuting SGBV cases in area of reporting of incidences, data harmonization, capacity building, and interagency collaboration. Again, the establishment of a referral pathway with relevant stakeholders to facilitate smooth administration of criminal justice, such as the EFCC on forensic, Legal Aid Council, Nigeria Police Force, amongst others. Again, designation of courts on GVV by the Chief Judge of the FCT, of 4 courts in the FCT to handle all cases of gender-based violence and deployment of interventions in this regard. Now, on prosecution of criminal matters under the mutual legal assistance. By mutual legal assistance, Nigeria is not operating in isolation as far as mutual legal assistance is concerned. Nigeria, for example, as you may rightly know, has been engaging other jurisdictions for support as it relates to fugitives and those that have indeed evaded justice. Nigeria, in return, is equally cooperating and collaborating with the international community for the purpose of building that collaboration as it relates to criminal cases, for example. And that is what is known as mutual legal assistance. It is an assistance an arrangement that allows Nigeria to reach out to international community for assistance. So the Office of the Attorney General has succeeded in executing over 350 mutual legal assistance requests and over 50 extradition requests. There are people that were alleged to have committed crimes in other jurisdictions and perhaps maybe run into Nigeria. And arising from the mutual legal assistance support arrangement entered into Nigeria and other countries, we have a responsibility on demand to look at the demand, take judicial processes and steps to ensure at the end of the day, those fugitives are made to answer to the justice of what they have done. And Nigeria had equally received and processed over 50 extradition requests among other countries. Among these are the mutual legal assistance request from United Kingdom on trafficking in person, which led to the first conviction of the offender under the UK Modern Slavery Act on 13th April 2022. Other mutual legal assistance requests from Turkey, Italy, Spain, India, and United States of America on drug trafficking and other crimes have been successfully treated. Also, the Office of the Attorney General filed extradition proceedings against suspended DCP Abba Kyari, for example, in line with mutual legal assistance requests from the United States of America. The matter is still ongoing before the Federal High Court. So what I'm trying to say in essence, that we have, under the leadership of President Muhammadu Buhari, not only succeeded in establishing a local consensus to justice sector issues, but have succeeded in establishing international collaboration that had indeed paid off in view of the fact that criminals that runs out of Nigeria are being indeed extradited, are being indeed brought back to the country through the art of mutual collaboration rather than from the mutual legal assistance. But it may interest you to know that the mutual assistance request process is not only a function of enforcement. Necessary foundation was indeed laid by having a mutual legal assistance act, which was indeed passed into law by the government of President Muhammadu Buhari, and that is what laid the necessary legislative foundation for international engagement. Now I come to the asset recovery. Before coming in place of the government of President Muhammadu Buhari, the idea of international recovery of looted assets was not in any way coordinated, organized, and indeed enhanced through processes and procedure. So in line with the cardinal principle of the administration of President Muhammadu Buhari in the fight against corruption, we have achieved the following successes under the asset recovery and management effort of this administration. But let me reiterate further that what I am presenting in terms of successes associated with recovery were successes relating to the period under consideration. But by way of emphasis and perhaps referral to the future, previous successes, I think it is important to state on record that among the major recoveries made by the Office of the Attorney General was the $322 million recovered from Switzerland, which money was indeed deployed by the government of President Muhammadu Buhari in reduction of poverty. And that was what was used, arising from the international understanding, international consensus in the trader money, earn power, school feeding program, and associated social investment programs, and that had indeed translated to a massive reduction of poverty in this country. We have equally, for the record, recovered additional $311 million from US and indeed the UK, which money was in effect deployed in the execution of 3 major capital projects in Nigeria. I am talking of Second Niger Bridge, talking of the Lagos-Ibadan Expressway, talking of Abuja-Kano Expressway, which projects had indeed reached advanced stage. So for the first time in the history of this nation, recoveries were not only being made, but what they are deployed in terms of development of the nation are indeed being visibly seen. Now, coming to the period in consideration, which is the 18-month period we are talking about. I start with revenue generation and sale of forfeited assets. You are aware that the president has put in place interministerial committee that was saddled with the responsibility not only of identifying the forfeited asset, but indeed disposing them. So that committee has been working, and a total sum within the period in consideration of 18 months, a total sum of 1,823,788,146 naira 86 kobo has been generated so far from the sale of bid forms, because forms were sold for those that are interested to partake, and the actual sale of forfeited properties within the period of 18 months under consideration. Again, stamp duty recoveries. Arising from the legislations, the Office of the Attorney General is saddled with the responsibility of effecting recoveries. Among the recoveries that are legislatively sanctioned for the Office of the Attorney General are stamp duty. So an inter-ministerial committee on the audit and recovery of back years on stamp duty, because there has been a backlog, and then the need for recovery of such backlog from agencies, from indeed corporate bodies, among others, arose. So we put in place steps to ensure the recovery of these back years stamp duty. And I am happy to state that inter-ministerial committee engaged various recovery agents to recover and generate additional revenue for the government. This exercise also provided job opportunities for over 1,000 professionals, including lawyers, accountants, auditors, and financial consultants. The ongoing exercise has so far led to the recovery of the sum of 596,055,569 naira 47 kobo. International asset recoveries. Within the period under review, the 18-month period in contention, we have equally succeeded in making some international recoveries. In complying with the presidential mandates and foreign judicial processes, the ministry has recovered a total sum of 6,324,627.66 euro from various jurisdictions. And some of the recovered funds are equally being utilized in the financing of critical infrastructures, including Abuja-Kano Expressway, Second Niger Bridge, and Lagos-Ibadan Expressway. For your information, as it stands today, there exists a funding gap of around 329 billion naira, and the Office of the Attorney General, through these local, international, and associated corporate recoveries on stamp duties, is equally making drastic efforts to assist the federal government in ensuring that this project, the gap associated with the funding as it relates to these projects, are being addressed. So as a ministry, we are not only involved in prosecution, we are not only involved in fight against corruption, but we are deeply rooted in supporting the good governance of the administration of President Muhammadu Buhari as it relates to infrastructure funding arrangement. So due to the concerted effort of the office in conjunction with the relevant stakeholders, inclusive of the legislature, the president recently assented to Proceeds of Crime Recovery and Management Act 2022. For the purpose of institutionalizing the asset recovery program, the federal government felt there was a need to institutionalize it and have in place a legislative framework, because it is the foundation for the institutionalization and success of anything. When we have taken decision, when we took decision as a nation to fight corruption, we had in place legislations that put in place EFCC, ICPC, Code of Conduct, among others. And now we have taken a decision as a nation to institutionalize asset recovery. There is need as well to institutionalize them. And then how do we do that? We first have in place a demonstrating unit, asset recovery and management unit, which we realize had indeed paid off, taking into consideration the successes being recorded, and then we now have taken further steps in 2022 to have Proceeds of Crime Recovery and Management Act 2020, which is intended and targeted at institutionalizing the asset recovery process, both in terms of transparency, in terms of accountability, and in terms of institutionalization of SEM, to have in place a unit, an agency, an arrangement that stand the test of time, both in terms of transparency, in terms of accountability, and in terms of international best practices. So I now go through the impact of litigation efforts on the economy. In terms of litigation we are involved, I have given you an idea as to what we are doing in terms of checkmating criminalities in our system. I have given you an idea as to what we have done as a ministry in terms of supporting the infrastructural development of the nation. So I will now go to the specifics and give you an insight as to what we have indeed succeeded in doing through litigation in the art of supporting our economy. For the record, a total of 648 cases were instituted against the president, federal government, and its agencies before states, federal, and ECOWAS courts. And we were expected as a ministry to defend the federal government, ministries, departments, and agencies in that respect. The cases that were instituted, I'm talking of the 648 cases that we are defending against the interests of the federal government, are at different stages of trial. But one thing I can tell you clearly, and I wish to emphasize, is the fact that the Federal Ministry of Justice has indeed been diligent in providing the necessary defenses in support of the federal government. By way of digression, let me tell you, before this government comes in place, a lot of judgment debts were incurred, inclusive of the Paris Club that constitute a contentious subject of contention in the system. But one thing I can clearly say, ever since the coming in place of government of President Muhammadu Buhari, not a single major higher profile judgment was entered against the federal government. All the judgment debts in contention that we are battling to defend were indeed inherited judgments against the interest of the federal government incurred by the previous administration and certainly not by the administration of President Muhammadu Buhari. So, arising from the diligent defenses we have been undertaking, we have succeeded within the period of 18 months in addressing and avoiding liabilities on the part of the federal government that ran into around 54 billion, 888 million, 343,888 naira 52 kobo in naira. Those cases we diligently, successfully defended the federal government, which translated into naira and kobo avoidance of liability. Again, we have equally succeeded in defending the federal government to avoid liability in the sum of $507 million, $507,415,901.19 million. So these cases were handled by the State Council in the office of the Attorney General of the Federation, and not a kobo, was paid by the federal government as professional legal services for the defense of these cases. What I'm trying to state in essence, that we have succeeded as a ministry in building capacity of the lawyers in the office and in the chambers of the Attorney General, and they are these lawyers that have indeed succeeded in recording this feat in defense of the federal government. The ministry is also coordinating the defense of a number of international arbitration proceedings commenced against the federal government, which were rooted in the previous administration, mostly. Of special mention is the case of P&ID, in respect of which an arbitral award of 10 billion was inherited by this government. And as at the time we came in place as a government, this award was at the point of execution. But for the purpose of emphasis, let me state that the volume of the $10 billion arbitral award against Nigeria has the capacity to set us back in terms of healthcare, in terms of security, in terms of education. All what we have been witnessing in terms of military procurement couldn't have been possible if indeed that judgment was indeed executed against the interest of the federal government. So we have, for the first time ever, established a precedent. What precedent is that? That judgment, as at the time the government of President Muhammadu Buhari came in place, was already in place, and the time within which even to appeal against SEM had elapsed, much less of the time to seek for any stay of execution, among others. We have succeeded in putting in process, on account of which, for the first time was not only extended for the federal government to put in process for consideration, but then this judgment was stayed, and then we were asked as a nation to deposit 200 million pounds as a condition for stay of enforcement. We further took steps to challenge that aspect of the judgment of the order that says a federal government must deposit cash, 200 pounds cash. We challenged them, and we succeeded in setting aside the order demanding the deposit of 200 million pounds. And as it is today, we are happy to state that we have not only succeeded in staying the enforcement of the judgment, but are given an opportunity to contest the judgment, and we are hopeful. By God's grace, we shall triumph. So the ministry indeed had equally taken steps to defend the federal government in cases like arbitral proceedings relating to Sunrise Power, relating to Mambila, and a host of others, including of many others that we have won along the line. Now, coming to contract negotiations, as at the time the government of President Muhammadu Buhari came in place, we inherited contracts that were a product of in-house compromises, whereby, in effect, breaches are naturally triggered. And we have taken steps for the first time to ensure that contracts are not only vetted, but indeed they are vetted with exclusive public interest component in consideration as it relates to vetting SEM, thereby ensuring, above any other thing, that the interest of the nation is put at heart. It was the Governors Forum and not the federal government in the first place that engaged the consultant. 2, when eventually successes were recorded associated with the refund associated with Paris Club, the governors, collectively and individually, presented a request to the federal government for refund. And among the components of the claim presented for the consideration of the federal government was a component relating to the payment of these consultants that are now constituting the subject of contention. When the claims were eventually processed and paid to the Governors Forum, they indeed on their own, without the intervention of the federal government, took steps to make part payment to the consultants, acknowledging their liability over same. And then 4 or 5, when eventually they made such payments, at a point they took a decision to stop the payment. The consultants instituted an action in court against the Governors Forum. And what happened in court? They submitted to consent judgment. Thereafter, the federal government, under the administration of President Muhammadu Buhari, was requested to comply with the judgment and effect payment. The president passed on the request of the governors to the Office of the Attorney General for consideration. And I am happy to report to you that the governors individually and collectively provided the desired indemnity to the Office of the Attorney General, conceding, agreeing, and submitting that the payment should be made. And yes, and that was the basis and the ground on the basis of which we eventually took a decision advising the president that the payment should be made. And then along the line, there was a change of leadership of the Governors Forum. And all the noise making that is now being generated arriving from the Governors Forum is not only unjustified, but indeed a clear case of indeed absence of defense.